Hello everyone and welcome to the channel Ontario Law and the Older Person. And this video is about a kind of ageism in employment, though there might be some dispute whether this is actually about ageism or not. And this is about accommodation, older people who might need to have special kinds of equipment or different kind of shifts or what have you in order to accommodate their needs as an older worker. The warning: the information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decisions should be made based on this material. Any viewer who needs legal advice should contact a lawyer. And once again, we're going to start with the Human Rights Code. If any of you have seen my earlier videos, you know I bring this up every single time when we're talking about employment. So you might find it annoying, but just in case someone is seeing this video and none of the others, we're going to Section 5, Subsection 1 of the Human Rights Code. Every person has a right to equal treatment with respect to an employment without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. And then subsection 2 about harassment in employment. Every person who is an employee has a right to freedom from harassment in the workplace by the employer or agent of the employer or by another employee. Always keep that in mind. Because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. This is from the website of the Ontario Human Rights Commission. Human rights issues at all stages in employment. And this is where most of the content for this video came from. I find it the best single source of information. It goes into a lot of detail. This video is pretty long, so the link to this website is in the description. If you'd rather not hear me ramble on, you can go there and look it up for yourself. I've actually cut out some of the points just to make this video less than an hour long. I do have some additional stuff though at the end. You might find that interesting. These are pretty much directly from the text unless I tell you otherwise. So, A. Duty to accommodate to the point of undue hardship. The code requires an effort short of undue hardship, so not to the point of hardship, to accommodate the needs of persons who are protected by the code. It would be unfair to exclude someone from the workplace or activities in the workplace because their code protected needs are different from the majority. The principle of accommodation applies to all grounds of the code. So those lists of characteristics I read to you earlier about ethnicity, family status, all that, this is what they're talking about with grounds. But accommodation issues in employment most often relate to the needs of employees with disabilities, older workers, employees with religious needs, pregnant women, employees with caregiving responsibilities. A quote from the site: accommodation, took some stuff out there, may involve meeting the needs of someone based on the needs of the group he or she belongs to, or it may involve meeting the needs of a person assessed on an individual basis. Another quote: collective agreements or other contract arrangements cannot act as a bar to providing accommodation, To allow otherwise would be to permit parties to contract out of their code rights under a private agreement. Subject to the undue hardship standard, the terms of a collective agreement or other contract cannot justify discrimination that is prohibited by the code. This is something that's a little interesting to me. In a different video, I'll be talking about how unions can allow forms of what might be called discrimination in their agreements. And the fight is this a legitimate limit or not? So I'm wondering, is it only about accommodation where you cannot have these limits? Or is this a misrepresentation about how much flexibility unions have in order to get other goods, right? Oh, we want higher wages. That means maybe we cut back on these other kinds of rights. So something to think about. Employers and unions have a joint responsibility to find a solution when accommodation conflicts with the collective agreement. However, the employer has charge of the workplace and is in a better position to create measures of accommodation. Therefore, the employer can be expected to start the process of accommodating an employee. But the Supreme Court has also noted that it will not absolve a union of the duty if the union fails to suggest available alternatives. When the union and the employer discriminate, they have an obligation to remove or alleviate the source of the discrimination. If an employer and a union cannot agree on how to solve an accommodation issue, the employer must make the accommodation in spite of the collective agreement, unless it would cause undue hardship. If the union opposes the accommodation or does not cooperate in the accommodation process, then the union may be named as a respondent in a human rights complaint. So, an employee needs accommodation, it's the union who refuses to cooperate, then the union can be the one who is sued in a human rights issue, or possibly both the employer and the union. So, can play out in different ways. Unions have to meet the same requirements of demonstrating undue hardship. For example, if the disruption to a collective agreement can be shown to create direct financial costs, this can be taken into account under the cost standard. Another quote: "It is also expected that the appropriate accommodation to meet an employee's code-related needs might change over time. Thus, accommodation requests and steps taken must be monitored and adjusted as needed based on changes in the circumstances of the employee, employer, and the workplace." And I'm just wondering, as I have there, is this a legitimate expectation? This seems to be a very big task that must be maintained on a regular basis, or should it just be left to the employee to say, okay, I need more help at this time? Something to think about. Now, one thing that people don't tend to think about when it comes to accommodation in the workplace is that the employees also has responsibilities in order to manage accommodation. So they request accommodation. They explain why accommodation is required so that needs are known. Make his or her needs known to the best of his or her ability, preferably in writing. Answer questions or provide information about relevant restrictions or limitations, including information from healthcare professionals where appropriate and as needed. Take part in discussions on possible accommodation solutions. Cooperate with any experts whose assistance is required. Meet agreed upon performance and job standards once accommodation is provided. Work with the employer on an ongoing basis to manage the accommodation process. Discuss his or her accommodation needs only with the persons who need to know. This may include the supervisor, a union representative, or human rights staff. One thing that isn't made explicit in this list is that employees might not get the exact kind of accommodation they want, but can still function with a different kind of accommodation. So basically, it shouldn't be a matter of, well, what I want is the only option, otherwise it's discrimination. Maybe there's a different way to meet their needs. Many claims of discrimination arise from an employer cutting short an accommodation process because of a perception that an employee is not fulfilling his or her requirements. There are certainly cases where, despite an employer's best efforts to provide accommodation, this cannot be done because of an employee's unwillingness to cooperate. On the other hand, out of fear of stigma or discrimination, employees may hide accommodation requirements until it is absolutely necessary to disclose them. The fact that an employee has lied about accommodation requirements in an early stage of a job screening or application process is not relevant to the analysis of whether the employer met the duty to accommodate once an accommodation need has been identified on the job. Okay, and so my little question there, is it fair to expect an employer to hire someone when the applicant is deliberately withholding relevant information? So I think you can tell from my tone, I don't think it's fair. This person is hiring someone else with incomplete information, and accommodation could be a big requirement. I mean, it can result in needing to put ramps somewhere, buy different kinds of equipment, things of that nature. So, on the one hand, yes, there's that fear of discrimination. It is a legitimate fear, but on the other, we're saying to the employer, you could be hiring someone who is deliberately withholding information, and now you're getting smacked with all these requirements for accommodation, which can include costs that you didn't anticipate, or having to adjust someone else's job. I don't know what the answer is here, but I think the thought process is a little too one-sided about this situation. Similarly, employees may disengage from a flawed process of accommodation conducted by an employer. An assessment of an allegation that an employee's lack of cooperation undermined an accommodation process will always include a critical assessment of the sequence of events that preceded the breakdown in the accommodation process. If the accommodation process is inflexible, punitive, or not carried out in good faith by an employer, a tribunal might find that the employee's actions are reasonable in the circumstances and that it is the employer who has failed in its duty to accommodate. Unions have a duty to take an active role as partners in the accommodation process, share responsibility with the employer to facilitate accommodation, including taking an active role in suggesting and testing alternative approaches and cooperating fully when solutions are proposed. Respect the privacy of the person requesting accommodation. Support accommodation measures no matter what collective agreements say, unless to do so would create undue hardship. As you can probably anticipate, employers have the longest list of responsibilities, and they include that they accept the employee's request for accommodation in good faith unless there are legitimate reasons for acting otherwise, get expert opinions or advice where needed, take an active role in making sure that alternative approaches and possible accommodation solutions are investigated, and research various forms of possible accommodation and alternative solutions as part of the duty to accommodate. Keep a record of the accommodation request and action taken. Maintain confidentiality. Limit requests for information to those reasonably related to the nature of the limitation or restriction to be able to respond to the accommodation request. Grant accommodation requests in a timely way to the point of undue hardship, even when the request for accommodation does not use any specific formal language. Pay the cost of any required medical information or documentation. For example, employers should pay for doctor's notes and letters setting out accommodation needs. Where accommodation would cause undue hardship, explain this clearly to the employee and be prepared to show why this is the case. The evidence needed to prove undue hardship must be objective, real, direct, and, in the case of cost, quantifiable. The employer must provide facts, figures, and scientific data or opinion to support a claim that the proposed accommodation causes undue hardship. A mere statement without supporting evidence that the cost or risk is too high based on impressions or stereotypes will not be enough. Factors that are excluded from consideration and cannot be used to justify undue hardship include business inconvenience, employee morale, and customer preference. Collective agreements cannot act as a bar to accommodation requests. Only existing circumstances can be taken into account when considering undue hardship. Speculative risks and conditions that may arise in the future are not considered. For example, when a person with a disability has a condition that may deteriorate over time, the unpredictability and extent of future disability cannot be used as a basis for assessing present accommodation needs. A person with multiple sclerosis may, over time, become more easily tired, but it is not possible to accurately predict when and for how long or in what way this will happen. There is no doubt that an employer will likely have to spend some effort to accommodate its employees' needs. However, some degree of hardship is to be expected. Hence, the test in the code is undue hardship rather than mild hardship or reasonable hardship. An employer should only conclude that an accommodation request will amount to undue hardship after careful and rigorous consideration of all elements of the request and the organization's ability to meet it. So, when an employer is discussing that a form of accommodation will cause undue hardship, here are some of the factors that they have to demonstrate. So, the cost of providing accommodation, including outside sources of funding, meaning can they get outside sources of funding? Maybe they can get grants or something like that. An employer may be able to show that the cost of accommodation will cause undue hardship. Costs will amount to undue hardship if they are quantifiable. Well, that's about, proving the cost by being able to provide actual figures. This is how much it'll cost. Shown to be related to the accommodation. So if their employer is making changes for other reasons, they can't kind of lump in those costs with a claim that accommodation will bring undue hardship. So substantial that they would alter the essential nature of the enterprise, or so significant that they would substantially affect its viability. Quantifiable costs related to accommodation include all projected costs that can be quantified and shown to be related to the proposed accommodation. However, mere speculation, for example, about monetary losses that may follow the accommodation of the person, will not generally be acceptable. The financial cost of the accommodation may include capital costs such as installing a ramp or buying screen magnification software, operating costs such as sign language interpreters, personal attendance, or extra staff time, costs incurred through restructuring that are made necessary by the accommodation, any other quantifiable costs incurred directly because of the accommodation. And here are some business considerations or practices that can be used in part of this evaluation. So, the size of the organization, what might prove to be a cost amounting to undue hardship for a small employer will not likely be one for a larger employer. So, as you can imagine, a larger employer might have more financial resources or more people who can share in different tasks. So, one person might need the exact same kind of accommodation in one place versus another, but in one place it will be undue hardship. Can the costs be recovered in the normal course of business? Can other divisions, plants, etc. of the business help to absorb part of the costs? Can the costs be phased in, so much per year, or financed through loans? Can the employer set aside a certain percentage of money per year to be placed in a reserve fund to be used for accommodation? Another issue, health and safety risks. Health and safety requirements may be set by law, regulation, rule, practice, or procedure. They could also be set by the company itself or together with other companies in the same or similar kinds of business. Where a health and safety requirement creates a barrier for a person identified by a code ground, the employer should assess whether it can be waived or modified. If waiving the health and safety requirement is likely to violate the Occupational Health and Safety Act, the employer should come up with alternative steps based on the equivalency clauses of the OHSA. These clauses allow for the use of alternative steps to those specified in its regulations, provided the alternative steps offer equal or better protection to workers. Any such steps taken should be documented. How do you feel about this? So we have the government setting rules. This is what is necessary to keep people safe. And yet, in the need to accommodate one or more of those employees, the employer is able to come up with alternatives. What kind of expertise would the employer have in that situation? I just think this is a little alarming. I think it could open up a really nasty can of worms with people deciding what is needed to preserve safety when they might not have any legitimate area of expertise in that area. An employer can decide whether modifying or waiving a health or safety requirement creates a significant risk by assessing the following. Is the employee willing to assume the risk in cases where the risk is solely to his or her own health or safety? I think this can be a very dangerous idea. What if there isn't the greatest communication between the employer and the employee about the nature of the risk? What if the employee thinks they understand that something happens that they didn't anticipate? Is there the potential for lawsuits where some employee feels, well, I agreed to this, but not to that. They didn't properly explain it to me, things like that. So I think that can be a little bit of a dangerous zone right there. Has the risk been evaluated after all accommodations have been made to reduce it as is expected? Would changing or waiving the requirement be reasonably likely to result in a serious risk to the health or safety of other persons? What other types of risks are assumed within the enterprise? That might be a bit about what kind of risks are normal within that kind of job. So, for example, we would expect a person who is a cashier to have a safer environment than someone who might work in construction. What types of risks are tolerated within society as a whole, reflected in legislated standards such as licensing standards or in similar types of enterprises? The seriousness of the risk should be judged after the employer takes suitable precautions to reduce it. In evaluating the seriousness of risk, consider the following factors. The nature of the risk. What could happen that would be harmful? The severity of the risk. How serious would the harm be if it occurred? The probability of the risk. How likely is it that the potential harm will actually happen? Is it a real risk or merely hypothetical or speculative? Could it occur often? The scope of the risk. Who will be affected if it occurs? If the potential harm is minor and not very likely to occur, the risk should not be considered serious. If there is a risk to public safety, consideration will be given to the increased numbers of people potentially affected and the likelihood that the harmful event may occur. And here I'm going to take a stand that is the opposite of the Commission in this matter, and it might tick some people off, but I don't think accommodation should be given if there is any chance there is any risk to anyone else. It is the employee who's agreeing, okay, I might be harmed with this accommodation. No one else should be facing any kind of risk. So that's my stance there. You might disagree. In some cases, the need for accommodation is obvious and there is no need for special documentation. For example, persons who use wheelchairs will have difficulty entering buildings that have steps, and pregnant employees will often need more bathroom breaks. Even where some documentation is required, this does not justify a fishing expedition. For example, a request for adjustments to computer equipment related to diminishing eyesight would not usually justify a request to review the accommodation seeker's complete medical file. A careful approach to collecting documentation protects the privacy of the accommodation seeker and protects the accommodation provider from potential complaints. All parties must exercise good faith in seeking and giving information. Employers can ask for more information about an accommodation request in the following cases: where the accommodation request does not clearly show a need related to a code ground. So remember, we're following the Human Rights Code and there's a list of different characteristics, if you will. So yes, gender, ethnicity, age, family status, what have you. Say there's something happening in the workplace that someone doesn't like. It makes them feel uncomfortable in some way. If it doesn't follow the code, it isn't necessarily creating a right to some kind of accommodation. Moving on, where more information on the employee's limitations or restrictions is needed to find an appropriate accommodation. Where there is an objective reason to question whether the request for accommodation is legitimate. And I imagine that is a very scary area to step into, because basically the employer is saying, well, you claim you need accommodation, but I need proof. I don't believe it. That would be a tough situation. And I think there could be people getting into a lot of trouble if they ask too much. I don't know. What if an employee cannot meet a standard even with accommodation? If an employee seems to be unable to meet a standard, even with accommodation, the employer should step back and make sure that any such requirements are bona fide. Okay, what they kind of gloss over is that yes, there are situations where it doesn't matter how much accommodation a person has, they can't do any kind of reasonable job. So there are tribunal decisions about this matter. I find it kind of interesting that this website just kind of brushes that part under the rug. So this website focuses on different grounds. I've skipped those. I'm now just going to refer to the stuff under age, so older workers. Older workers may need accommodation for reasons such as disability and leave related to family status and marital status. For example, the need to care for a family member or an ailing spouse. So that's something I talked about in the video regarding hiring and policies such as needing to be available basically evenings, nights, weekends, with no predictability about the schedule. And so an older person might have more family responsibilities than a younger person. So an older person might not be able to apply for jobs like that, and that might be a form of discrimination. Anyways, moving on here. These obligations exist regardless of the age of the employee. However, due to a relationship between age and disability, these needs may become more apparent as workers and members of their family age. As an older worker makes the transition to retirement, employers may be called on to provide accommodation in the form of flexible hours and conditions of work, part-time arrangements, and job sharing. In some cases, retirees may be rehired as consultants or on short-term contracts. There may also be a need for changes to workstations, additional training, or other steps to help older workers meet essential job duties. Older workers should be assessed individually to make sure that the accommodation meets their changing needs and capacities. So I have a few questions here, and I know the way I'm talking, you might think I value employers over employees. Uh, I do believe employees are entitled to more accommodation than we get. But again, this is some stuff here that I think would be too much to expect from an employer. So, for example, this employee is heading into retirement, so they want a part-time job instead of a full-time job. Well, that means the employer either needs to hire another part-time worker or shift those responsibilities onto another employee. Is that fair? Or why, if a person is retiring, why is there an obligation to hire them back as consultants? So I think this might be a little too much to ask, but you might disagree. It'd be something to talk about. Example, an older worker finds a physically demanding task challenging. The employer should either assign it to someone else if it is not one of the essential duties of the position, or if it is an essential duty, seek other ways to accommodate the worker to the point of undue hardship. So here we have a situation where a job or task might be added to someone else's job. Is it right to expect another person to take on that responsibility? Are they going to be compensated for that additional task? Or is another part of their job going to be eliminated so that they can accommodate this new task? So this is another situation where we're focusing on the person needing accommodation and not the impact on another person, in this case, a colleague. It is difficult to find, especially recent, tribunal decisions or court decisions where the focus is on a failure to accommodate due to age. While you'll have a decision that is talking about age discrimination in the workplace, when it comes to accommodation, they're usually talking about some kind of physical disability. So as the employee aged, they were less able to do certain tasks associated with their health, for example, not as mobile or can't see as well. So it is hard to find something, especially something recent. I decided I might as well go with this little decision. It is an example of someone saying something should be accommodation and the tribunal deciding, no, it's not. So the parties, Frost, so that's the applicant, versus and Carson Dunlap Associates Ltd. Paragraph 6. The tribunal's jurisdiction is limited to enforcement of the code. The code only prohibits actions that discriminate against people based on their enumerated grounds in a protected social area. This means that the tribunal does not have jurisdiction over general allegations of unfairness unrelated to the code. Then they say, look at this other court decision. Paragraph 7. By virtue of their humanity, everyone will identify with at least one code enumerated ground, and over the course of their lifetime, most people will suffer some form of adverse treatment which may or may not be connected to the code. Because of this, the code does not assume that all adverse treatment is discriminatory. So in another video, I talked about this person who brought a case against her employers, claiming various forms of age discrimination. And in fact, the tribunal threw out most of those claims because they're not necessarily based on ageism. So she was talking about interactions with other employees. And to me, I have to say, it looked more like a clash of personalities. She seemed kind of judgmental. And so some of the stuff she was saying, it was just, okay, that wasn't a positive interaction, but what does it have to do with age? She couldn't demonstrate that it did. So being in an unpleasant situation isn't necessarily a violation of your code rights. There's other ways where people can be jerks and unpleasant. Paragraph 9. After a careful review of the application and the submissions in response to the request, I, that's the panelist making the decision, find that the applicant has not provided a connection between their termination and their age, except for alleging that the termination will have a disproportionate impact on the applicant because it will be more difficult for an older individual to find new employment as compared to a younger individual. The applicant, however, does not allege that their age was in any way a factor in the decision to terminate them. Okay, so something I've addressed in other videos. Sometimes an organization might be making policies or rules or expectations with no thought to For example, oh, this means older people can't do it. Nowhere in their heads. But maybe that policy has a disproportionately harsh impact on, let's say, older people. So this could still be considered a form of discrimination. However, does this involve discrimination? So maybe this person was fired for totally legitimate reasons. He doesn't say that they were illegitimate, but so they were fired for a good policy reason, but the result is harsher on older people. Does this amount to some kind of discrimination, what we would call adverse effect discrimination? Or is this just to be expected within a properly functioning business? Someone flat out can't do the job and therefore they're to be dismissed regardless of age. Paragraph 10. The applicant appears to be arguing that the respondent had a duty to accommodate them by offering them any alternative age-appropriate employment instead of terminating them. It appears that the applicant is arguing that the applicant is owed this accommodation because they will have a more difficult time finding new employment because of their age. In their submissions in response to the request, the applicant stated that the respondent ought to have known that, at the age of 63, my prospects were negligible to nil for obtaining equivalent employment as a high-level consultant outside of Carson Dunlap. Please refer to the Appendix A. That is why I filed my HRTO application for age discrimination against Mr. Roswell. Okay, if you read the actual decision on the website, it's very short. There's no information about whether there is any such alternative position within the company. So what is this person claiming? We don't know. We don't have the information, but are they claiming there is already in the organization a job that would meet these requirements? Or is he expecting the company to just make up a new position that he can work in? And there is case law saying no, an employer is not required to just flat out make up a new position just because this person requires accommodation. That would be undue hardship. This is the last little bit for this video. This is paragraph 13. And in this paragraph, the decision maker for this case is quoting a decision maker from a different case. That's why we have the larger indent there. It's a direct quote. So, paragraph 13. As was explained by the tribunal in name of other case, the duty to accommodate in respect of employment is not a freestanding obligation under the Code. It arises only pursuant to sections 11, 17, or 24 of the Code, where an employee is disadvantaged because of a prohibited ground of discrimination under the Code. Basically, they're just saying the behavior has to fall into the description provided by the Code. Not every behavior that has a negative consequence is going to be covered by the Code. Moving on. In other words, what the Code prohibits is discrimination, whether direct or adverse effect. That's what I described in the earlier slide. The Code does not require accommodation in the absence of discrimination. Thus, an applicant who claims that his employer has breached its duty to accommodate him is really claiming that he has experienced direct or adverse effect discrimination because of disability. That's relevant to the other case. And that his employer cannot justify the discrimination by showing that the applicant could not be accommodated without undue hardship. Okay, well, what's happening here is this person was fired for legitimate reasons. So he himself says it's not about age discrimination, but he is saying being fired, someone else being discriminatory will give him a negative impact. And while that's true, this current employer is not the one engaging in discriminatory behavior. Therefore, they can't be held accountable for a form of accommodation and the lack of providing it. It's because others might be ageist. So paragraph 14, in these circumstances, I find the application does not fall within the tribunal's jurisdiction. Because it's not covered by the Code, the tribunal can't do anything about it. So that's the end of this video. I know it was a bit of a long, dry one. So if you got to the end, I'm glad you got to the end, and have a great day.